welcome to my YouTube channel. My name is David Okon. Today I'll be talking about work and pay, in particular, looking at behaviors of employer in relation to employee in terms of paying the national minimum wage, and we will also look at different categories of these issues, and including what wages might or might not be in every sector of the economy. In this aspect, we will be looking at retail employment, which is the biggest sector in the UK to employ, are also number one in terms of size. So we're looking at what wages counts as wages in the United Kingdom in the retail employment sector. The definition of wages from which deductions can be made is the same as that in the employment. What deduction can the employer make? Stay tuned, continue watching. If you haven't subscribed to this channel, subscribe to this channel, and also click notification bell to get a new video when it is posted. And also watching the video, share with family and friends. So in retail employment, an employer may, if the contract or a written agreement authorizes it, make deduction for cash shortage or missing stock due to, for example, dishonesty by a worker or a theft by a customer. If an employer makes a deduction from employee's pay for a cash or a stock shortage, the employer must give details in writing to the employee on the pay on the pay day. Any deduction for missing cash or stock must be made within 12 months of the employer discovering the shortage. Stay tuned, continue watching, leave a comment below. Let us talk about these issues. This rule applies for the first deduction if the total to be deducted is spread over a number of pay days. Stay tuned, continue watching. As always, thank you so much for being part of this economy within this part of the process in this platform of YouTubing. When can a deduction be made? The employer can only make a deduction or the first in a series of deduction within 12 months from when the missing stock or cash shortage was discovered or reasonably should have been discovered. Stay tuned, continue watching, leave a comment below and let me know your thoughts on this material. And if you watch this video, watch it alongside the other videos, which this is a continuation of. And how much can deduction for cash shortage, missing stock be? These are specific issues or industrial. And leave a comment, let me know your thinking in terms of this material. I regard them to be extremely useful, and if you can access the gov.uk public site of Citizen Advice. Citizen Advice is the UK's largest, biggest organization providing advice service, mainly legal advice and also policy in terms of its applicability in the practical sense of the word. So the size of the deduction that an employer can make depends upon the amount of gross wages that the worker is due to receive on their payday, and an employer can only deduct up to 10% of the wages due on that particular payday for cash shortages or missing stock. This deduction is in addition to any deduction under the rules for all our workers. If the amount to be deducted is less than 10%, the employer can deduct the full amount. If the amount of the deduction is more than 10%, the employer can only deduct 10% on that payday, but the balance may be carried over to the next day, to the next payday, aside when the 10% limit will again apply. Leave a comment below and let me know what your thoughts are. In terms of this policy, there is no limit to the amount of money that an employer can deduct in total from a worker. The only limit is how much they can deduct on each payday. If the worker is leaving work, you can see below also. Final payments when the client in retail employment is leaving work. We are looking at different situations and also what you might or might not need to do to resolve a certain situation, because you see, industry of any sort, including employment, is active. So it's not passive. So this material is illustrative of the activity, what really happened in the employment sector in the United Kingdom in real time. So when an employer is leaving employment, when they're leaving work, what happens? If the employer has not been able to deduct all the money to cover cash shortages, missing stock that the worker owes because of the 10% rule, the employer may be able to deduct the balance due from the final payment of wages when the worker leaves the job. So the 10% rules does not apply to the final payment. Talk about the final payment, leave it on below. So the employer can deduct money that is owing to them as follows. From the final payment made to cover the last period worked. For example, if the client is paid weekly, this will mean deduction from the final week's wages. This will mean deduction from the final week's wages. Any pay in lieu of notice included in the final sum will also count as final payments, or from any pay in lieu of notice if this is paid later than the above. Stay tuned, continue watching. The employer cannot make deduction from any money that is paid for a period of work outside the final period. For example, the worker has worked 1 week in hand. They would decide 2 weeks' wages when they left, but only the week's wages for the last week would count as final earnings. The employer can ask for a payment, and if they do, if instead of making deduction from wages, the employer asks for a payment from an employee in retail employment, they must let the worker know in writing of the total amount owed and make the demand on one of the client's paydays following the notification, and make the demand within 12 months of first discovering the shortage, or when they should reasonably have discovered the shortage, and not ask for more than 10% of the worker's gross wages, and give the demand to the worker or post it to their last known address. Stay tuned. Continue watching. Leave a comment below. So if a worker is already having a deduction for cash shortages, missing stock made from their wages, the employer cannot also demand a payment which would mean the worker losing more than 10% in total of their gross wages on any payday. If you comment below, let me know what you're thinking. If your employer has made a demand for a payment under the 10% rule and has not received the payment, they can ask again for the unpaid amount. at the same time as asking for another 10% on the subsequent payday. In effect, this would mean that 20% would be asked for. Stay tuned, continue watching. Let us look how a worker can dispute deductions. He can negotiate with the employer. Worker should always first try to deal with a dispute with an employer by negotiation. So, if they feel uncomfortable doing this, it may help for the bureau or any other to negotiate on their behalf. If the worker thinks they might be working for an umbrella company, but it's not clear whether their contract is with the umbrella company or the agency, they should complain to both at the same time. They should put both company names and addresses on all communications. Stay tuned, continue watching. So where you have identified that the worker is protected by the legislation or their contract, this will strengthen the worker's position and should encourage the worker to settle the dispute within the worker having to take further action. You can go online to learn more about negotiating with an employer. So raising a grievance. An employee should raise a grievance in writing with their employer about the unlawful deduction from their wages, if there is time to do so within the time limit for making a tribunal claim. Stay tuned, continue watching. So if the worker thinks they might be working for an umbrella company, but it's not clear whether their contract is with the umbrella company or the agency, they should raise a grievance to both at the same time. But both company names and addresses should be put on all communication. To learn more about raising a grievance in England, Wales, and Scotland, you can access the internet in any of the respective websites. So you can make a claim to an employment tribunal. If the employer has made a deduction which is unlawful under the Employment Rights Act 1996, and raising a grievance or negotiations with an employer have failed, the worker can make a claim to an employment tribunal. The worker can make a claim to a tribunal even though they are still working for the employer. They do not have to have left their job. They do not need to have worked for the employer for a particular length of time to make this claim. There are no fees for employment tribunal claims. More about what to think about before you make a claim to an employment tribunal. Stay tuned, continue watching. Thank you so much. In England, Wales, and in Scotland, you must notify ACOS of your potential claim before you can make a claim to an employment tribunal. The early conciliation procedure applies to most employment tribunal claims and will affect the time limit for those claims. To learn more about early conciliation, you can visit the website. Thank you so much. Stay tuned. Continue watching. So in England, Wales, Scotland, you must notify ACOS of your potential claim before you can make a claim to an employment tribunal. The early conciliation procedure applies to most employment tribunal claims and will affect the time limit for those claims. To learn more about early conciliation, visit the internet as always. So if the client decides to make a claim, they must go through ACOS early conciliation before they can go to an employment tribunal. Going through early conciliation gives the client more time to make a tribunal claim. They will have at least 1 month after the end of early conciliation to make their claim, and possibly longer. They must start ACOS early conciliation within 3 months, less 1 day of the date the deduction was made from their wages, or the date they should have been paid the money they are owed. Stay tuned. Continue watching. There's been a series of deductions. The time starts from the date of the last in the series, or the last non-payment of money owed. If you are in a situation and you are a retail worker, your employer can ask for a payment to cover a cash or stock shortage rather than making a deduction from their wages. So there are special rules about the maximum payment their employer can ask for. If the employer breaks those rules, your client must start ACOS early conciliation within 3 months, minutes 3 months minus 1 day of the date the payment was made. If you're interested to know about time limits for making a claim to an employment tribunal in England, Wales, and in Scotland, you can visit the internet, you can go online. So you can look at claims for unauthorized deduction from wages made on or after the 1st of July 2015, which are limited to 2 years. This means that tribunals will not be able to award unpaid wages for any deduction made more than 2 years before the date on which the claim is presented to the tribunal. We'll talk about deadlines. This limitation does not apply to claims for unpaid statutory sick pay or SMP. Talk of statutory maternity pay, for example. So alternatively, claims other than claims for unpaid statutory holiday pay can be made as breach of contract claims in the county court, sheriff court in Scotland, where claims can be made for up to 6 years before the date of the claim, 5 years in Scotland. Thank you so much. Stay tuned, continue watching. So the tribunal can order either full repayment if the deduction or payment should not have been made at all, or repayment for any excess deduction or payment that has been made. If your clients are if your client is an employee, they could claim unfair dismissal. If their employer dismisses them for complaining about an unlawful deduction from their wages, taking a case to an employment tribunal. It does not matter how long your clients has worked for their employer. So if your client is a worker, they cannot claim unfair dismissal, but could claim that they have suffered a detriment. If you're interested to know more about how to apply to a tribunal in England, Wales, and Scotland, you can visit the internet also for unfair dismissal. Thank you so much. Stay tuned. Continue watching. Good morning. Welcome. So, claiming consequential losses as a result of an unlawful deduction from wages, in addition to ordering repayment of unlawful deduction from wages, the tribunal can allow a worker to bring a claim for any consequential losses they have suffered. It's a direct result of an unlawful deduction from wages. This could include bank charges or interest accrued. You can take court action if the worker cannot make a claim to an employment tribunal about a deduction because the deduction is lawful under the Employment Rights Act and Northern Ireland Order, or because it is not covered by the Employment Rights Act NI Order, or because the time limits have expired, but they wish to dispute the deduction, they could take court action. They may be able to sue the employer for damages for breach of contract. If a client needs to sue the employer to get their money back, they need to establish the correct identity of the employer. A trading name has no legal standing. The client must determine whether they are or were employed by an individual or a limited company so that the employer can be named correctly in the claim. Stay tuned. Continue watching. Thank you so much. The client can find out whether the business is a limited company by looking at the letter A or any signs or documents which give the business name. If the name ends in limited, or PLC, limited, a public limited company, the business is most likely to be a limited company. Sole traders and partnership may trade under their own name. For example, Sarah Green, a plumber, or under a business name, for example, Speedy Car Wash, or about forms of business, organization, and liability for the debts of the business. The procedure for taking legal action will depend on whether the business is a limited company or the business is not a limited company. The business is a limited company. The limited companies exist as separate legal bodies. The owners or directors' liability for the company's debt is limited. This means that the company's directors are not personally liable for the company's debts unless they have been convicted of fraudulent trading. If the company is a registered charity, the trustees may be personally liable. You can find details about a company on the Companies House website free of charge. If the firm is a limited company, the client must claim against the company itself and can use the company's trading address or head office address. If the business is not a limited company, it will be either a partnership or a sole trader. The employee can claim against the business itself, that is the business name and the trading address, or the owner at either the trading address or their home address. If the business is a sole trader, it is usually better to sue the owner, as they will be personally liable for all the debts of the business. If the business is a partnership, his partner is fully liable for the debts of the business. It is best to sue all the partners, or as many of them as are known. The employee cannot first sue one partner and then, if the partner does not pay, sue another later. Stay tuned, continue watching. How to find the owner's name and address. Businesses which do not trade under the name of the owner or partner have to include, display, or give the name and address of the owners or partners. Thank you so much. So this can be given on businesses, on business letters and stationery. It can be written on written orders. It can be given on written orders, invoices, receipts. It can be given on any demands for payments. It can be given to suppliers or to customers when asked to do this. So a home address does not have to be given. The business simply has to give an address where documents, for example, a claim form, can be solved if necessary. The telephone directory may give a home address against a person's name. How to start action. Starting a court action in England and Wales. If an employee wants to start a court action, they will need to complete a form. You can look more online about completing a form. So if the employer defends the claim, the court will usually allocate the case to the small claims track if the claim is for 10,000 or less. That is in pounds. Or the fast track claim and 25,000 if it is between 10,000 and 25,000 pounds. You can find out more about the procedures in the small claim tracks in England and Wales. Also, you can look more about the procedure in the fast track in England and Wales. So, in which court should the employee start proceedings? All county court money claims must be issued at the Civil National Business Centre, CNBC. The Civil National Business Centre, CNBC. So where the claim becomes defended or requires a hearing before a judge, the claim will be transferred to an appropriate county court. So if the claim is for a fixed amount, and the employer is an individual, this will be the employer's home court. In all other circumstances, the claim will be transferred to the claimant's preferred court. Stay tuned, continue watching. The claimant should give details of the court where they would prefer the claim to be transferred by filling out the section marked preferred court. Stay tuned, continue watching. Thank you so much. Stay tuned, continue watching. Subscribe to this YouTube channel if you haven't subscribed. Click like, click notification bell, and share the video with family and friends, leaving a comment. Let us look at Scotland. If you're applying to the sheriff court in Scotland, if the employee wants to start action in the sheriff court, there are two types of civil procedure depending on how much money is owed. So if the sum owed is less than 5,000, they should use the simple procedure in the sheriff court. So more than 5,000, they should use the ordinary course procedure in the sheriff court. This is a more formal procedure, and the employee will usually need to use a solicitor. Solicitor is a lawyer. Normally they are specialists. Normally they are expert lawyers representing clients in the United Kingdom courts, but they cost money. Normally they cost money. They are not free unless the government gives legal aid policy. So the employee should start court action by completing a claim form for the a simple procedure, or issuing an initial writ in the order or the ordinary course procedure in the sheriff court. And if the employer owes a lot of money, or the case is complicated, the client should have to use the court of session. They should seek legal advice about what action to take, looking at taking civil legal action online to learn more about that can be done. And as always, so let us look at the which court should the employee apply to in Scotland. So the employee should apply to the sheriff court, which is nearest to the employer's business address or registered address, if it is limited company, and if the employer is a sole trader, or the business is a partnership, the employee should apply to the sheriff court, which covers the employer's or partner's address. Where there is a choice, the employee should apply to the sheriff court, which is most convenient to them. If the wrong court is chosen by mistake, the sheriff court will usually direct the case to the right court. Stay tuned, continue watching. Thank you so much. Non-payment of wages would usually be a fundamental breach of an employment contract. Such a breach would entitle an employee to resign and claim constructive dismissal. So the employee would then have to claim that the constructive dismissal was unfair. And claiming constructive unfair dismissal should only be considered as a last resort. The client are entitled to, under the legislation, to claim an unauthorized deduction from wages. They would not have to give up their job, and would have more protection from dismissal. You should therefore consider all other options before considering constructive dismissal. An employer can actually take action. An employer can also take action if the employer makes a demand for a payment which is lawful under the Employment Rights Act in Northern Ireland order, but does not receive it. They can take court action and also take action to recover the money from the worker. However, since the employer can legally deduct the money from the worker's wages, it is unlikely that they will take court action unless the worker has left work. Stay tuned, continue watching, leave a comment below, let me know what your thoughts are. Let us look at retail employment. If the employer makes a demand for payment to recover a cash shortage or a missing stock, and the client does not make the payment, the employer could take legal action for recovery of the money. They will have to make the demand for payment within the 12 months time limit, but could then go to court at any time. However, in practice, this rarely happens. Let's look at the rules about the limit of 10% on deductions from wages on any one pay day, applying to any order that the court makes about the rate at which the worker should make any payment to their employer. If the worker is about to leave their employment or has already left, 10% limit does not apply to the rate at which the court can order the client to pay the money to their employer. It will be up to the court to decide how the money will be paid depending upon circumstances. The circumstances. Stay tuned, continue watching. Thank you so much. So claiming
some see the original, mighty the god, the magical radical. Hey, representing my magical, young Jose come million. Jamaica wacha, that defta, kina teach me kenyo Jamaica kopa. That wacha, kina damage me kenyo Jamaica wacha. That defta, kina teach me kenyo Jamaica kopa. That defta, kina damage me kenyo. Gangsta the kamele there. Come on, there we are there for the bed. We have a day, you're my baby. Every day I call you, my know you're my treasure. Baby, got no machina, yo. If I be quacking yo, when it's over to Koda, baby, got the machina, baby, got your quara. You are said bandana, you must say bandana, you must say bandana. Baby, got no tema, come a quagga.
Let us look at now getting paid when you leave a job. This applies to England. It also applies for to Northern Ireland, and also you can check for situations in Scotland and also situation in Wales. To check, nobody check pay slips. You talk to your employer. You get help from ACAS and early conciliation. You should also take legal action. If you haven't been paid the right amount after leaving a job, you can take steps to get what you are owed. You need to act quickly. The deadline for taking action is usually 3 months, less 1 day from when your employer should have paid you the money you are owed. This is often the same date as your last pay date. But it's a good idea to check the date your employer should have paid, when they should have paid you what you are owed, in case it was due on an earlier date. On top of your basic pay, you could be owed a holiday pay, sick pay, if you are off sick in your notice period, maternity, paternity, adoption, or shared parental leave pay, redundancy pay. If you're owed redundancy pay, your deadline for claiming is 6 months minus 1 day from the last day when you are employed. So your employer must pay you everything you are owed in your last pay packet, even if you've been dismissed. If you owe them money, they might be able to take it from your pay. You will usually get your last pay on the date you are normally paid. For example, if you leave at the start of the month, but you are usually paid at the end of the month, you'll probably have to wait until then to get your final pay. Check with your employer if you are not sure. Stay tuned. Continue watching. Thank you so much. So if you haven't left your job yet, check with your employer to make sure you will be paid everything you are owed, including for holiday you're entitled to. You know if you owe your employer any money and how you will pay it back. So you can also check your pay slip. Start by checking your final pay slip. This will help you see how your final pay was worked out. Check whether you have been paid for the number of hours you worked, any holiday you are owed, any notice or redundancy pay you are expecting, any sick pay you are expecting, any maternity, paternity, adoption or parental leave pay you are expecting, overtime, commission or bonus you are expecting. You should also check if your employer has deducted money you weren't expecting. Also, if you are an employee or a worker, you have a legal right to a pay slip to show how your pay has been worked out. If you get paid per hour, your pay slip to show how many hours you have worked. Stay tuned. Continue watching. If you haven't got a pay slip, or your pay slip doesn't show how your payday has been worked out, as your employer to put this right. You can check if you are an employee or check if you are a worker on gov.uk. So you can talk to your employer as well. If you think your final pay is wrong, try speaking informally to your employer. So if you can get through on the phone, you could try emailing, writing a letter, or phoning your old workplace's main telephone number. You could try speaking to the human resources or payroll department if there is one. Ask them to explain anything you don't understand on your pay slip or why you haven't been paid. If you don't agree with your employer's explanation, explain what you think the correct amount is and ask them to pay the money you are owed as soon as possible. Stay tuned and continue watching. So if you're negotiating with your client's employer, if you are an advisor, you can negotiate directly with your client's employer. This might work if their employer hasn't responded to direct contact from your client. If you write a letter, you could include how much the employer owes and how you have worked it out. These are sections for people who might be advisors what your client could do next if the employer doesn't pay. When your client could start legal action, your letter should also ask your client's employer to confirm they agree to the calculation and will pay the money owed by a certain date. It's a good idea to include a letter of authority signed by your client with the letter, otherwise the employer might not respond or you could lose time while the requests are the same. If the employer won't negotiate or right getting close to the time limit for a tribunal claim, it might be better to go straight to ACAS, early conciliation, or take a legal action. The time limit for making a tribunal claim is 3 months minus a day from the date as the last deduction was made. Common issues also can arise, which can be looked into if you are paid by the hour. Check if you have been paid for the number of hours you have worked in the time period your pay slip covers. So if you have been paid for the wrong number of hours, get evidence of the hours you have worked. You could use the things like copies of old rotas, clocking in records, emails from your employer confirming your shifts. This will help you challenge your former employer to get the money you owed. Stay tuned, continue watching. You can also take a look if you are still owed holiday paid, and if you leave partway through here, you might not have taken all the holiday you are entitled to. So your employer has to pay you for any holiday you are legally entitled to but haven't taken. This is called pay in lieu of holiday. You can use the holiday entitlement calculator on gov.uk to work out how much holiday you are legally entitled to. So in case you leave work before your holiday is due and you are entitled to that holiday, you can still be paid that holiday. Perhaps in the year. Stay tuned, continue watching. Check your employment contract to see if you are entitled to more. Example, it might say something like your basic annual leave entitlement is 20 days. You are also entitled to 8 paid bank holidays. Your contract should say what happens to any contractual holiday you have built up but haven't taken. You are only entitled to be paid for it if your contract says so. If it doesn't say anything, you are unlikely to be paid. You could ask your employer if you can take the holiday as days off during your notice period. Stay tuned, continue watching. And if you are still owed holiday pay, get together any evidence that will support what you are saying. You could use a printout of your results from the holiday entitlement calculator, a copy of your contract saying how much holiday you are entitled to, at least showing the holiday you have already taken. This will help challenge your employer to get the money you are owed. And also, if you are an advisor, you can calculate holiday paid, or and in one way or the other using you can find more detail to calculate holiday pay. Or these are material helping people like you and I, and also advisors who are doing so in their professional capacities. So if you haven't been paid redundancy pay, also if you have been made redundant, and you will usually be entitled to redundancy pay if you have worked for your employer for at least 2 years. You can check your entitlement to redundancy pay and what to do if you don't get it. Stay tuned, continue watching. Leave a comment below about this policy and let me know what you think. If you're in the UK, if you're outside the UK, so your employer has deducted money from your pay if you owe your if you owe your employer money. They can usually only take it out of your final pay. If your contract says they can, this could include money you owe for holiday you have taken but weren't entitled to. You can use the holiday entitlement calculator on gov.uk to check if this applies to you. Contractual maternity pay also, if you didn't go back to work after if you go back to work after getting extra maternity pay, fees for courses for employer paid for loans from your employer. The only time your employer can take money without an agreement in your contract is for wages you were previously overpaid. Let us look at the situation. You can check your contract to see what is always about paying your former employer back. If it doesn't say your employer can deduct money from your pay, they are not allowed to do so. If you think you have taken they have taken money wrongly, you can take steps to get it back. and you can look at guidelines for advisors in terms of authorized deductions. You can check if your client has had authorized deduction online. You haven't been paid the sick pay. You can check what you can do if your employer refuses to give you sick pay. If you are sick during your notice period, you might be entitled to sick pay or your normal pay, working out how much you should have been paid. It can be complicated. It's a good idea to talk to an advisor as always. So if you're an advisor, if your client has resigned, they should get the sick pay rate they're entitled to. For example, statutory sick pay. In some cases, they might be able to get a full pay for 1 week of their notice period if they are off sick. You can check what sick pay your client is entitled to in their notice period. If your client has been dismissed, you can look at this. The amount of sick pay they can get depends on whether they get a statutory notice or contractual notice. You can check how much pay your client should get in their notice period if they are being dismissed. If your client has been made redundant, the amount of sick pay they can get depends on whether their contractual notice is at least 1 week more than their statutory notice. You can check how much pay your client should get in their notice period if they have been made redundant. If you haven't been paid maternity, paternity, adoption, or shared parental leave pay. If you qualified any kind of statutory parental leave on the date your job ended, you should get it even if you leave your job. Your employer should keep paying it until you are no longer eligible. You won't have to pay it back. For example, if you worked for your employer for 26 weeks before your qualifying week, you are entitled to 39 weeks statutory maternity pay. Even if you leave your job, your employer should still pay it to you even if you resign before the statutory maternity pay starts. If your employer gives you more maternity pay on top of your statutory entitlement, check your contract. It might say you need to pay some of it back if you don't return to work. You can only be asked to pay back anything extra you got on top of your statutory pay. You can check if you are entitled to statutory parental pay and read your options at the end of maternity leave. Stay tuned, continue watching. So you can look at a situation where your employer has gone out of business. It can be difficult to get money you are owed if your employer goes out of business. Your options depend on how you have gone out. How they have gone out of business. If your employer has just stopped trading, you can take steps to get some of the money you are owed. Stay tuned, continue watching. If they have gone out of business, which could be called bankruptcy, administration, or liquidation, you can claim some of the money from the government. You might not get it all back. There is a limit to how much you can claim. Stay tuned, continue watching. You might be contacted by the person in charge of sorting out money the business still owes. They are called an insolvency practitioner. They will help you claim from the government and will add you to the list of people the business owes money to. However, you still might not get everything you are owed. You can check what steps to take to claim money your employer owes you on gov.uk. An advisor can also take steps to look at money owed by an insolvent employer. You can help your client to get money owed by an insolvent employer. So if talking to your employer doesn't work, you can also, if you haven't left your job yet, you could raise a grievance. This is a way of formally raising a problem at work. Your employer can't ignore it. And check if your employer has not a grievance procedure for you to follow. You might find details of your staff handbook or internet. If your employer doesn't have a grievance procedure, or you have already left your job, try writing them a letter. It should include the date you left, how much you think they owe, and how you have worked it out. When you expect to be paid, copies of any evidence you have got to back up your argument. You might be able to get help from a trade union or other organization. They could negotiate for you and go to meetings with you. This could give you a greater chance of success. You can read more about raising grievance. Stay tuned, continue watching. Thank you so much. An advisor can also help in raising a grievance. You can help your client to raise a grievance. You can't contact your former employer if you are in this situation. If your employer stop trading or move, you can try this method to find them. Search for their details on the company's house website. If it was a registered a limited company, you can search for them online as well. So you can contact a trading standard department of your local authority. Visit your old workplace to see if there is a notice saying for the firm has moved. Contact the landlord or estate agent of your old place. You can also pay attention if you are an advisor. If your client's employer offers some of the money, your client's employer might agree to pay some of the money in full and in final settlement of the claim. Accepting the money won't stop your client from taking further action to get the rest of what they are owed, unless the agreement is one of a court's 3 agreement. These are drawn up by ACAS. A settlement agreement drawn up after your client received independent legal advice. A settlement agreement will only stop your client from taking legal further action if they receive independent legal advice. This has to be from a solicitor, barrister, or advisor who is certified to advise on settlement agreements. Your client's employer should pay for it. Get help from ACAS and early conciliation in writing to stay tuned.
MVC record.
Bravo, Jesus, on the beat.
So if writing to your employer doesn't solve the problem, you can contact ACAS. It provides free independent support for employment disputes. Get in touch with ACAS as soon as you can. The deadline is 3 months minus a day from when your employer should have paid you. Stay tuned, continue watching. Thank you so much. They will see if your employer will agree to a process called early conciliation. This means they will help you talk at your former employer and try to resolve the dispute informally. You can apply for early conciliation on the ACAS website and read more about using early conciliation. You can also take legal action if you don't reach an agreement through ACAS early conciliation. You can make a claim to an employment tribunal. You need to have tried early conciliation before you can go to a tribunal. ACAS will give you a certificate that you need before you can start a tribunal claim. If it's more than 1 month since the date on the ACAS certificate, you might be out of time for a tribunal claim, but you might be able to sue your employer in the courts instead. You should get advice from the nearest citizen advice about your options. I have explained about citizen advice before, and also in this video if you watch carefully. So if you're an advisor, you are helping to take legal action to get money owed by an employer, and it's usually best for your client to make a claim in the employment tribunal. They might need to claim in the civil court instead if either they have missed the deadline to apply to the tribunal. They might be self-employed contractor. So you can check if your client should claim in the employment tribunal or the civil court. These are information for advisors. So explain that legal action can take a long time and help your client weigh up the benefits and costs. You will need to help your client evaluate their claim. Enforcing a tribunal or court judgment, your client's options for enforcing a tribunal or court judgment depend on whether their employer is solvent. Check what your client can do if their employer is insolvent, and also you can do this online. If the tribunal decided your client is entitled to a redundancy payment, your client can apply to get the payment from the redundancy payment service on gov.uk. They won't have a reference number because their employer is insolvent. They might find it easier to call or email redundancy payment services using the details on that page rather than filling in the form. If your client's employer owes them other money and their your client believes the employer can't pay their debts, your client can apply to make them insolvent. This is complicated, so your client will need to get help from a solicitor. Stay tuned, continue watching. Thank you so much. Making a person or a company insolvent can be expensive. It's most likely to be worth it if your client shares the cost with other people they worked with. You can check how to make a company insolvent on gov.uk. So the gov.uk pages calls this winding up a company. Stay tuned, continue watching. Thank you so much. You can look at pay generally again, but getting a job reference, and this is advice applies to England, and it also can apply to Northern Ireland, Scotland, and also in Wales. And you can, under this condition, you can consider how to get a job without a reference from your employer, getting a reference from your old employer. If you think you have had a bad reference, you will usually need a reference from your old employer when you are looking for a new job. If your employer gives you a reference, they can make it as short as they like. A lot of references only say what your job title was and when you worked there. The reference has to be accurate. Your employer can't say anything that's not true. They also have to be fair when they decide what to put in the reference. For example, they can't say you were investigated for stealing if the investigation decided you hadn't done it. Stay tuned, continue watching. Thank you so much. If you haven't been dismissed, your employer can include the facts. For example, if you have been dismissed or they were thinking of dismissing you. Stay tuned, also continue watching. Thank you so much. Think about how you will explain what happened to a new employer. It's best to focus on the facts rather than how you feel. This will make it easier to show you acted reasonably. Thank you so much. Stay tuned, continue watching. If you are being investigated or disciplined, your employer can literally your employer can say if you are being investigated or disciplined. They can't say you definitely did it if the process is still ongoing. It's usually better to stay in your job until the process is finished, even if you are dismissed. If you are found innocent, your employer shouldn't mention the process in the reference. If you are disciplined or dismissed, the new employer can see you took part in the process. You can find out what to do in a disciplinary process. Think about how you will explain what happened if you are disciplined. It's best to focus on the facts rather than how you feel. This will make it easier to show you acted reasonably. There are some situations where resigning and leaving immediately will clearly be the best option, because staying in your job would harm your health. For example, if you don't feel safe at work or your colleagues are repeatedly bullying you, find out what to think about before you resign. If you have a criminal conviction, if your employer can't mention any spent conviction, your employer cannot mention any spent conviction you have. They should only mention an unspent conviction if it's relevant to the job. For example, if you were convicted for stealing from work. Stay tuned, continue watching. Your convictions unspent. Your convictions is if your conviction is unspent for a certain amount of time after it ends, and for example, if you pay fine, your conviction is usually unspent for a year. After that, it's spent. It takes longer for some convictions to become spent than others. Check if your conviction is spent on gov.uk in the United Kingdom. Getting a job without a reference from your employer. Stay tuned, continue watching. Thank you so much. If you think your employer will give you a bad reference or won't give you a one at all, you could ask someone else to give you a reference instead. Look for jobs that don't need a reference from your most recent employer. Some jobs accept references from other people you have worked with, like a different manager or someone you have worked for before. Try to choose someone you have worked with recently. It also helps if they have a senior position in the company. Check with them first to make sure they'll give you a good reference. Stay tuned, continue watching. The new employer might ask why you are not giving your old employers details. Think about how you will explain this to them. You will need to give a reference, a form from your old employer if a job application asks for it, but you might be able to give a reference from the other person as well. Getting a reference from your old employer. Your employer doesn't usually have to give you a reference unless your contract says that they will. You have written proof they have agreed to give you a reference, like an email. Some regulators also say employers have to give references, for example, the Financial Conduct Authority. If your old employer doesn't want to give you a reference, you could ask them just to give a short one known as a basic reference. For example, they could confirm when you worked for them and what your job title was. And a lot of employers only give basic references, so your new employer won't think it's unusual. And you might be able to speak to someone else if you don't want to contact your manager directly, for example, an HR department, a human resources department, or another manager. If you think you have had a bad reference, it's worth asking either your new or old employer to see a copy of your reference. They don't have to give you a copy of it, but they might choose to. If they give you a copy, you can check what your old employer said and ask them to change if it is not true. don't wait to see your reference before you apply for other jobs. It might take a while to get it. Asking your old employer to give a good reference next time. Think about if you can ask your old employer to give a better reference in future. You might be able to speak to someone else if you don't want to contact your manager directly, for example, an HR department or another manager. I explain what the problem is and how you would like them to help. Be as specific as you can and focus on the facts rather than how you feel. And for example, if you have lost a job after a job offer because your old employer gave a bad reference, you could tell your old employer you were offered a job but it was withdrawn because of the reference, and ask them to review the reference to make sure it was fair and accurate. Ask them to confirm they will give a fair reference in the future. Taking action against your previous employer. If you have lost out on a job because your employer gave you an unfair reference, you might be able to take them to court. Going to court can take a long time, and you might not win your case. For many people, it's quicker to look for another job or ask someone else to give a reference instead. Your nearest citizen advice can help you decide if it's worth taking your employer to court. So an advisor can work out if your client, if their clients can have a case. So your client might be able to make a claim if the employer is discriminating against them, they have been treated badly or for another reason that's legally unfair, known as a detriment. They have suffered a loss because their employer gave an untrue or unfair reference. You can also check and if your client has been discriminated against. So your client might have been discriminated against if they have been given a bad reference or refused a reference because they have complained about discrimination. Helped someone who was being discriminated against find out what's protected by the Equality Act. They might also be able to claim if the reference says something discriminatory, for example, revealing their sexual orientation. They will need to make the claim to employment tribunal within 3 months minus a day after the discrimination has happened. Now, speak to an employment specialist and contact the expert advice team if your client would make a claim. So you can check also if your client has suffered a detriment. Your client might be able to claim for a detriment if they have been given a bad reference or refused a reference because they were pregnant or on a parental leave, as for their legal rights at work, example, to be paid minimum wage, took action about a health and safety issue, worked in a shop or a betting shop and refused to work on a Sunday, were a trade union member and took part in trade union activities including official industrial action, or they were acting as an employee representative and therefore raised a concern to their employer about wrongdoing known as whistleblowing. If they have worked for their employer for at least 2 years, they might also be able to claim for detriment if the bad reference was because they didn't declare a spent conviction. They will need to make the claim to an employment tribunal within 3 months minus a day after they suffered a detriment. And speak to an employment specialist or contact the expert advice team if your client wants to make a claim. Stay tuned, continue watching. Thank you so much. Check if your client can claim for a loss. If your client hasn't been discriminated against or suffered a detriment, they will have to to prove their employer was either negligent. They should have known what they were saying wasn't true, malicious. They were deliberately trying to harm your client's chances of getting a job. They will also have to show the reference was a reason for their loss. It's normally only a good option to make a claim if your client has suffered a big loss, like being rejected for a highly paid job. It can be difficult to win the case because the courts try to make sure employers feel confident giving references. It can also be expensive. Your client will need to get a solicitor to present them, and they might also have to pay court fees. Stay tuned, continue watching Legal Crown the Law. They will usually need to make the claim in the civil court rather than the tribunal. The kind of claim we would need to make depends on what the reference says. For example, they might not need to claim for breach of contract or defamation. Stay tuned, continue watching. Thank you very much for your help. Speak to an employment tribunal specialist or contact the expert advice team if your client wants to make a claim. And stay tuned, continue watching. Thank you so much, and we'll see you in the next material when we get to a situation where we are in the process and of ending this process, and also continuing with the process as always. And see you in the next one, also talking about pay, in terms of employment, in terms of the minimum wage, in terms of all the elements. Complexity has been exciting, it has been also challenging, and Legal Crown Law, we are work in progress. Subscribe to this YouTube channel if you haven't subscribed, and Legal Crown Law, click the notification bell, click like every day to help. And if you watch the video and share with family and friends so that you don't enjoy it alone. I'll see you in the next one. Thank you. Bye bye.